Welcome to our webinar, Don't Let Florida Go to Pot. Now I would like to introduce Peggy Sapp. Peggy Sapp is President and CEO of Informed Families and Volunteer President of the National Family Partnership. Peggy has over 30 years of experience in the prevention field at the local, state, and national level, and she has served on the advisory councils of the White House Office of National Drug Control Policy, the National Institute of Drug Abuse, and the Florida Governor's Office of Drug Control. Please join me in welcoming Peggy Sapp.
Thank you, Amy. I am delighted to be here. I love all this new technology that we have. We're all in different places, and maybe that's the way life is. We're all in different places, and we hear different information, but our children hear a common theme that goes throughout America, not just in their school or in their family. It's reinforcing information that we need to give them. And I guess I started out as a volunteer mom doing this, certainly not as an expert, and I don't even know that I consider myself an expert now. Now I'm helping to raise, not helping to raise, but I'm up here in Lexington, Kentucky, babysitting teenagers. So it seems like I'm always with a bunch of teenagers. Nobody fights you much for teenagers, you know. That's an interesting experience. And they ask tougher questions today than I think they did when my children were teenagers. But the one thing I know for sure is there are two things that drive drug use. And one is the perception of harm. If you don't believe something is harmful, you're very likely to use it. And the other one is availability. And those two things are fact. I feel like that this has been a 30-some year battle or fight about the same topic over and over. But maybe that's because each person, each teenager, each parent has to finally hear it for themselves. You can't hear it for someone else. So we are delighted to have this panel with us because they're a panel of experts. And I don't know about you, but life is so complicated today. We need to rely on experts for them to share with us an in-depth knowledge and understanding. So welcome to each of you out there watching our webinar. We're delighted that you're here to hear our experts. And remember, you can just talk to us anytime you want to, and because we're listening. So Amy, I'll let you go with the panel.
Yes, thank you, Peggy. And we'd also like to thank the Florida Sheriff's Association, without whom we could not have done this webinar. They've been an incredible partner to us on multiple projects, and this content is really created by them, and we really appreciate it. I'd now like to introduce Susan Kelsey. Susan is a solo lawyer in Tallahassee with over 26 years experience in appellate practice. She's worked on 18 constitutional amendment cases, half in favor of and half opposed to the amendment. She, together with former Florida Supreme Court Justice Ken Bell, prepared and filed briefs opposing Amendment 2, the medical marijuana amendment. She's continuing to work against Amendment 2 on a pro bono basis and has met with several newspaper editorial boards and helped write educational materials about the flaws in Amendment 2. Please join me in welcoming Susan Kelsey.
Thank you, Amy. I really appreciate the opportunity to be here, and thank you to everyone who is taking the time to become informed about Amendment 2. The first thing I'd like to say about Amendment 2 is that we must get up and vote. This is very close. Right now, the latest polls reported today are showing that Amendment 2 is going to pass. We have to get out the vote. We cannot just sit back and let this happen. Please go vote. Second, please read the amendment. When you do go vote, you will see a ballot summary that's only 74 words. But the full text of this amendment is 1,196 words long. It's 2 full pages, front and back, small type. So it's very important that you go and read the amendment. And when you do, you will see that the flaws that you've been hearing about are very real. They are written in the amendment in plain language that anyone can understand. This is not something we are making up. One of the first problems with Amendment 2 is that it should not go in the Constitution. Putting it in the Constitution creates a practical problem and a very serious legal problem. The practical problem is that we cannot change it at all, not the first word in it. We can't change it at all without another constitutional amendment. And we can only do that every other year, every 2 years in a general election. And it would still have to pass by 60% of the vote. So we could only, our experience shows us that there is a need to change something in it, we'd have to live with that for 2 years at least until we could get it on the general election ballot, and then it would have to pass by 60% of the vote, and that is extremely difficult to do. Now, the legal problem with putting Amendment 2 in the Constitution is that you are giving it a higher status than any other law in Florida. The Constitution is the highest law of the land, and it trumps or supersedes all statutes and rules. So when you hear people on the other side of this issue say, well, the legislature is going to fix it, that's probably not true, because the legislature is not authorized to change or limit or restrict the Constitution in any way, and neither is the Department of Health. The Department of Health and the legislature cannot limit, restrict, or change the Constitution. So their hands are tied. Unfortunately, the people who wrote Amendment 2 put so many operative details in the amendment to go in the Constitution itself that they've tied the hands of our lawmakers, and they will not be able to fix the problems with Amendment 2. The other legal consequence of putting this in the Constitution is that you are giving constitutional status to a private industry, which is unprecedented. And it's not just any private industry, it's the drug industry. Now, once that is in the Constitution, they are going to claim that they have rights. The users are going to claim that they have rights that are constitutional and they cannot be infringed. So what we're going to see is that any attempt by the legislature or the Department of Health to narrow this or tighten it up or fix it is going to be met with lawsuits. And ultimately, it's going to be up to the courts of Florida, not the legislature, not the Department of Health, but the judges of Florida will have to construe the amendment when it's challenged in court. And the rule of law is that those judges have to apply Amendment 2 as written. The exact words that go in the Constitution have to be implemented according to their plain meaning. So you can see why we say you can't fix it. We have to vote on it as written. And the fact that we're putting it in the Constitution is going to create unintended consequences down the road that we are going to regret having to live with. The second major problem I see with Amendment 2 is that it really does create de facto legalization. Some proponents are trying to say that it's very narrow and it's only for people with debilitating medical conditions. And it is certainly true that that phrase is used in the amendment. The problem is, what is the definition of a debilitating medical condition? Amendment 2 lists 9 specific conditions or diseases that will qualify for using medical marijuana, but then it has this open-ended catch-all phrase that says, or other conditions if a Florida licensed physician determines that the benefits outweigh the risk. So those physicians are supposed to recommend it only for debilitating conditions, but there is no uniform or objective definition. There's no safety net. There's no requirement that a second physician, for instance, agree with the first physician. So it's entirely up to the physician, and an unscrupulous physician or a doctor who's just more lenient will be willing to recommend the use of medical marijuana for any condition. And that's going to cause, of course, users to flock to those more lenient doctors as the word gets out, which is going to recreate the pill mill situation that we just had to fight down in Florida. So the way it is written, and again, it has to be implemented according to its exact words, does create de facto legalization, in addition to just putting a lot more marijuana in the stream of commerce. Another problem with Amendment 2 is its broad immunity provision. It says that everyone from the doctors to the patients, to the caregivers, to the growers, the processors, the manufacturers, sellers, they are all not subject to criminal or civil liability or sanctions under Florida law. Please read that in the amendment. It is startling, and it's in the first section of the amendment. No criminal liability, no civil liability, no liability for sanctions under Florida law. that covers the waterfront, and that extends extremely broad immunity. That, again, ties the hands of the state, where we cannot hold people accountable for what they're doing wrong under the amendment. These are three of the things that I think are extremely problematic about the amendment, and although I am very sympathetic to people who are sick, people who are hurting, perhaps people who are at the end of their lives, I'm compassionate as anyone else is, as we all are. But the question is not about compassion. The question is, how are we going to implement that compassion? The question on the ballot is a legal question. Are we going to do it on these exact terms? Are we going to put these exact words in our Constitution? I've studied this for the last year of my life, and I cannot support Amendment 2. So I encourage everyone to please vote, and please vote no. Thank you.
Thank you, Susan. Thank you so much. And if anybody has any questions for Susan, please enter them into the question section on your screen, and we'll get to them after everybody has had a chance to make their presentation. Next, we are so fortunate to have Sheriff Jerry L. Demings of Orange County. Sheriff Demings is a native of Orlando, Florida. He received his Bachelor's of Science degree in Finance from FSU, in his Master's of Business Administration degree from Florida Metropolitan University, Orlando College. Sheriff Demings is a 1998 graduate of the 194th session of the Federal Bureau of Investigation's National Academy and 2000 graduate of the 23rd session of the FBI's National Executive Institute. On November 4th, 2008, Sheriff Demings was elected the first African-American sheriff and constitutional officer in the history of Orange County. Please join me in giving a warm welcome to Sheriff Demings.
Thank you for that wonderful introduction. I'm honored to be here today to participate in this webinar with Informed Families as you take the leadership role in standing against something that would prove to be bad for families in Florida. I want to start by also telling you some things about myself that perhaps you did not know. First off, I've been a street cop. I've worked every level of law enforcement, and for a significant portion of my career, I had the opportunity to work in narcotics and work and put a number of individuals in jail in our state. In addition to that, I'm going to give a little bit of a personal testimony. In 1999, my oldest brother died as a result of drug addiction. And I stand with the millions of American families and Floridians who have had a loved one that they've lost as a result of drug addiction. And what I can tell you is that if my brother had known what would have been the ultimate effects of his flirtation with marijuana and other narcotics, I don't believe that he would have ever started experimenting for the 20 years or so that he was drug addicted. And so this is something that is personal with me, and I believe that all Floridians should come out and vote against it. This is not about being compassionate for a family member. We certainly, as Florida Sheriff, are very compassionate when it comes to taking care of our citizens. We supported back in the springtime the legislation that ultimately was passed and signed into law where the governor signed the Compassionate Medical Marijuana Act, which would create the opportunity for individuals to receive a low dosage of marijuana other than in a smokable form. It would be in an oral form that would be taken to assist those individuals who will have debilitating illnesses. And now fast forward, we're talking about passing a form of a law that would allow smokable marijuana. So that's the perspective from which I'm going to talk this afternoon. There are a number of loopholes regarding this issue. First off, there's the pot for anyone loophole. Not many people realize that if this amendment passes, you will not be required to obtain a physician's prescription because one is not needed. the physician would only be able to certify you to go to one of the dispensaries. If this is truly about medicine, I would listen to my doctors, but the ones who are really speaking the loudest happen to be from the legal profession. They're not physicians. When we look at our professional physicians associations, such as the American Medical Association, the National Cancer Institute, the American Cancer Society, and the Florida Medical Association, our doctors have all come out and said that this is bad for Floridians. It's bad because in some ways, when we try to define what a debilitating illness is, what is included in the amendment is very broadly defined. It would essentially result in any condition perhaps being qualified for the certification of medical marijuana. And those conditions could be minor types of illnesses, and there's a high potential for abuse of smokable marijuana. The various medical research entities such as the National Institute for Drug Abuse have indicated that there's no acceptable medical use for smoked marijuana, and I believe that the majority of physicians would support that position. In addition to the pot for anyone loophole, there's a drug dealer loophole. That's what we say as Florida sheriffs because of the so-called caregiver rule. There will be no requirement for individuals who would be caregivers to have any type of medical training. In fact, it would even allow a caregiver to possibly have a felony record. They could have been a drug dealer in the past. The opportunity to become a caregiver would essentially be easier than obtaining a driver's license here in Florida because it doesn't require a lot of training or certifications or what have you. The next loophole that we refer to is, we call it the teenager loophole. Teens and children would be able to purchase without parental consent. The amendment is silent in regards to age restrictions. Effectively, it would guarantee confidentiality of a person who is prescribed not prescribed, but certified to receive the medication. Even the parents would not automatically receive the information. The next loophole is what we refer to as the pill mill loophole. There are no restrictions currently in the amendment where these dispensaries could be located. It is likely that they could be located throughout your respective cities and counties unless your counties or cities pass ordinances that would restrict their locations. That will result in a lack of uniformity across the state in terms of where these potential dispensaries will be located. Much like the pill mills of yesteryear, Florida had a major problem just a few years ago in that we had pain clinics that had emerged across the state, and they were in various places. And anecdotally, I will tell you that these pill mills were located in commercial centers near restaurants, schools, churches, and so without some specific ordinance or a law that would restrict where these locations would be in your communities, they could be everywhere, and that would be bad for Florida. And at this point, I believe I'm done with my portion, and we're moving to the next section.
Okay, great. Thank you so much, Sheriff. We really appreciate all of those excellent points. Now it's my pleasure to introduce Karen Bailey. Karen is a mother and real estate professional who resides in Ocala, Florida, with her husband, who's a practicing dentist. She serves on the board of directors for the State of Florida Prescription Drug Monitoring Program Foundation. Please join me in welcoming Karen Bailey.
Thank you. In September of 2011, I lost my son to a drug overdose. His attitude toward marijuana was like that of many people who are in favor of legalizing it. He viewed it as a natural rite of passage, safer than alcohol, and something that would soon be legal. Florida should not legalize marijuana because it is a gateway drug that is addictive and damaging to the teenage brain. Moreover, without FDA regulation, there's no way to monitor the drug's potency. My son fell into the habit of taking pills in order to maintain the buzz he got from pot. Those pills became an addiction he could not control, and ultimately they took his precious life. 60% of teenagers do not think marijuana is harmful, but there's ample evidence that marijuana is addictive and damaging to the undeveloped teenage brain. 1 in 6 children become addicted to marijuana after using it just once. My son shared with me that he first tried marijuana in middle school. 90% of addictions start in the teenage years. My mother had a rare spinal tumor that left her bedridden the last 4 years of her life. My family understands the need for pain management during difficult medical circumstances, but there are other already approved medical options for them. Saying no to legalizing marijuana in Florida does not make us a less compassionate or loving state. It is out of love for our children and those like my son that we must say no. Thank you.
So the first question that we have is, and I think that this is the best question for Susan Kelsey to answer, why can't the legislature and the Department of Health fix loopholes in Amendment 2?
Well, that's a good question, and it's an important one to understand because that's what the proponents, the supporters of Amendment 2 are saying, you know, just chill. The legislature is going to fix this. The legislature is conservative. They'll take care of all this. Well, no, they may try, and we would hope if the worst happens and this amendment passes, we hope that the legislature will try to make it as narrow as possible. But here's the problem. Once you put a right in the Constitution, you can't restrict that right through a general law. So that's what these proponents of this amendment did when they started writing this amendment. Now, they could have said, the legislature won't act on this, so we will pass a constitutional amendment saying the legislature shall enact laws authorizing the medical use of marijuana for certain conditions, period. Now, if that's all they had said, then yes, the legislature could fill in all the details. But they didn't do that. What they did was they tied the legislature's hands, and they went ahead and created all of these details and all of these rights in the Constitution itself. And what that means is, under the rule of law in Florida, the legislature and the Department of Health are not allowed to limit those rights once they've gotten in the Constitution. The Florida Supreme Court did not say that Amendment 2 is okay. All that proceeding did was decide whether or not it could go on the ballot. It's called an advisory opinion proceeding, and they're required to issue an advisory opinion in every citizens initiative case just to determine whether or not the amendment should go on the ballot. So that's the limit of their jurisdiction. The court specifically says in these cases, and the court said in its opinion in this case, we are not passing on the merits of the amendment. We are not passing on the merits of the amendment. So when you hear people say, well, the Supreme Court has spoken, or this is now the law of the land, what the Supreme Court said is it's okay to go on the ballot. And people need to understand also that this was a very narrow decision. There are 7 justices on the Supreme Court. 4 of them voted to allow this to go on the ballot. The other 3 justices wrote a very strong, vehement objection. They dissented and said it should not go on the ballot, that it is full of loopholes and flaws, and therefore it is deceiving to the voter. And in addition to those 3 justices who are current justices, you may have seen on the news or seen in the newspapers that 7 former Florida Supreme Court justices felt so strongly about this that they joined into a letter to the editor that was published statewide in September. So 7 former Florida Supreme Court justices said, we have looked at this amendment and we cannot support it. And they urged all of Florida to vote no on it because it should not be in the Constitution and because it is full of flaws and loopholes. So you've got 3 of the current justices and 7 former justices who are, at the top of the legal hill in Florida. They know what they're talking about, and they said vote no on 2. So coming back to the original question, didn't the Florida Supreme Court approve this? They approved it to go on the ballot. They did not resolve all of the problems that exist because of its loopholes.
Well, thank you so much, Susan. The next question is, I noticed that you used a lot of statistical statements in this presentation. Do you have a list of references so that others may review and use similar sources? Are these measures specific to Florida? I could answer that question. We will be happy to provide you a list of references and citations. We have all of that, and we could provide it to everybody after the webinar. And are these measures specific to Florida? No, they are not, but we have the latest Florida Youth Survey in our hands, and we can certainly provide you information about that as well, if it is available from that survey. The next question is, marijuana is illegal under federal law. If Amendment 2 passes, will there be an issue with the federal government if it's in practice? I guess that question would be for you, Susan.
Well, Sheriff Demings may be able to talk a little bit about that, the impact on law enforcement after I'll address it from the legal standpoint, and then perhaps he can address it from the law enforcement standpoint. But yes, it's important to remember that marijuana is still illegal under federal law, and everything that happens or would happen under Amendment 2 is a violation of federal law. That ought to bother people a lot. And the only reason that the federal government has not been enforcing the federal law in other states is just because of the views of the current administration. The former Attorney General Eric Holder sent a letter out, basically kind of an opinion letter saying, we're not going to interfere with states to have a medical marijuana law. That doesn't change the fact that it is still illegal under federal law. And so, for instance, that's why you hear about it being an all-cash business, because banks, which are regulated by the federal government, are not allowed to do business with the drug industry. So you have it an all-cash industry, which makes it much more prone to crime and to difficulties like that. And as I said, it ought to hurt some consciences that this is still illegal under federal law.
And I'm going to chime in also, Susan. You're absolutely right. It will create major conflict for those of us in the law enforcement community. In order to carry our firearms, each state has certain rules and laws about how its citizens can qualify to carry firearms. And there's also rules about law enforcement officers and qualifications, etc. And there's something in federal law that also says that a law enforcement officer may not possess a firearm if they use certain types of unlawful drugs, including marijuana. And even in those states where the states legally pass either recreational or medical or marijuana laws, a law enforcement officer will still find themselves in violation of federal law because it is still unlawful under federal statute. So a law enforcement officer cannot be a law enforcement officer and use marijuana even if it's legal within their respective states because of this current situation. In addition to the issues that would impact law enforcement, there would be other workplace issues that employers would have to make some decisions regarding, especially those who work in high-risk environments where safety is of the utmost concern. How will they create policies and procedures regarding their employees who have to work in those safety-sensitive environments? Be a major challenge there as well. So this is also a challenge for individuals who think that they'll be able to receive their medical marijuana through the mail. They will not, because, again, the U.S. Postal Service would not be allowed to ship this via the mail because of this violation of federal statute. So there are unintended consequences that many have not thought about and adequately processed.
Well, thank you so much, Sheriff. I also want to mention to everybody that there's a lot of great resources and statistical information at don'tletfloridagotopot.com. That's a very good resource if you're looking for this research. The next question is, if the Amendment 2 passes as written, will a child get arrested if caught with marijuana? Susan? Sheriff?
I'm sorry, I couldn't hear the second half of the question. Will a child get arrested for what?
If caught with marijuana. So the question was, if the amendment passes as it is written, will a child get arrested if caught with marijuana?
They should. The sheriff can talk about that. The question is, what about minors using it? And as the sheriff pointed out, there's no age limit in the amendment. That's important, and that comes full circle around to the significance of putting something in the Constitution. What the amendment says is that all qualifying patients have a right to get their medical marijuana. Now, a qualifying patient is defined as anybody who gets that recommendation from their doctor and then goes and gets the card from the Department of Health, okay? So if that happens to be, say, a teenager, your 16-year-old or your 17-year-old, if you've got children that age and you remember when you were that age, you can do things behind your parents' backs. And so at that age, they are able to go and make this happen. And if you can do that, then and show your medical marijuana card, then you would have an out. I think you would have to, the sheriff can address how the law enforcement would handle that. But it absolutely can happen that they would get the card and then not be subject to arrest. Now, people have said, no, because Florida law already requires parents to consent to all medical treatment for their children. Well, no, there's not a statute that says that. You're going to hear that, but there's not a statute that says parents have to consent to all medical care for their children. There is a common law principle that parents and guardians have the right to control their children's medical care. But here again is the problem with putting this in the Constitution. It takes priority over that common law principle. It says a person of any age, doesn't have any age limit, who gets the qualifying patient recommendation from the doctor has the right to get the marijuana. And then it also says that has to be kept confidential from everyone. So you put those two principles together and you do have teenagers getting pot. Now look, nobody's saying your 6-year-old is going to be able to do this because obviously they can't make the logistics work to get to the pot doctor. But it's a very real scenario. And one other point I would like to make is that before Amendment 2 was being circulated, this group was circulating another petition related to medical marijuana from 2009 to 2013. They had another petition trying to legalize medical marijuana, and in their first draft, or their first attempt, they did include a prohibition against minors using medical marijuana without their parents' consent. They did have an age limit. Then in 2013, they wrote Amendment 2, and they took the age limit out for minors. I'm just baffled as to why they would do that, because when you're writing for the Constitution, what you put in and what you leave out have consequences. So having said that, I'll let the sheriff address, how this would work if a, sheriff's deputy sees some teenagers and they're smoking pot and one of them pulls out a medical ID card, how would that work?
Well, essentially how it would work is if the child had a medical marijuana card, then they would seemingly be under that exemption. They would not be subject to arrest. But if a child does not have one of the cards, then they would be in violation of the law, and the law enforcement officer will have the discretion whether or not to make a custodial arrest of that child. The officer could, in some cases, issue a civil citation, which is essentially ordering that person to show up at a court date at a later date, but not taking that child into custody. So the law enforcement officer would have discretion if it's misdemeanor amounts of marijuana.
Thank
Amy?
you. Yes.
I want to just say something here, because there are two parts of this that I think about. I think the general public is really so tired of hearing about the marijuana thing that they don't want to hear about it anymore. I think, unfortunately, what they really aren't realizing is if you pass Amendment 2, you're going to be hearing about this a whole lot more than you are now. And you're going to be hearing about it in ways that we haven't even thought of. I know Colorado is experiencing a lot of problems. I have a friend who does international shopping center leasing, and they have two major tenants in a big shopping area. So then they had space in between. So they leased it out to a medical, I don't even know what they call those people, but it's a dispensary because it's legal there, right? Well, the first thing that happened was all the insurance rates shot through the roof. Unintended consequences. So you don't think those merchants were talking about that? Sure they were. That was bad. But the next thing that happened were robberies and one killing in the parking lot. So now the leasing agent, and Susan can appreciate this, right, or Karen, is that all of a sudden they're saying to the leasing agent, get them out of here, get them out of here, get them out of here. Well, how do they do that? Unintended consequences. Kid has a medical marijuana card. He shares it with his friends. So, folks, if you think we're just trying to get out of something, taking the easy way out is not getting out of it. It is making it worse for us with Amendment 2. So I think there's that side that's sort of the sweeping side. Oh, I'm tired of hearing about it. Let's just legalize it. It'll be okay. So maybe we're all complacent in that. How many times you turn off the news because you don't want to hear any more about whatever they're talking about. But the other part of it is there are people who really look at this as huge industry. This is follow the money, folks. That's a big rule. Who is going to benefit from this? This is a growth industry. Look at who's backing it. So I think that's important to think about. Who's backing this? What kind of money are they trying to make? Is that really a good thing? Just because it's legal doesn't mean it's right. So again, I think that unintended consequences are going to be big if this amendment is passed. So I surely hope that people vote no for Amendment 2. And
Thank you.
yeah,
Thank you,
I'll
Peggy.
stop at that. And Amy, I do want you to ask me later about tipping points.
Okay. The next question, actually, Peggy, you might be the best person to answer, and that is, will the zero drug tolerance policy at schools still be enforced if this passes?
Well, I think it's a mixed message. We're an expert in a society of mixed messages. We say one thing and we do another, and that really does go to the tipping point. I think schools will all debate this, and they'll say, but I think they really will take a stand that says, this is not a good idea for kids. The stronger you make your stand, the more important it is. One of the things I learned is fascinated me. It's called the tipping point in any kind of an epidemiology thing that we're dealing with in destructive and dangerous behaviors. There is a 10% propensity in a population for a destructive behavior. Now, you need to recognize that, and that's where we so get into mental health issues and all kinds of things that are interrelated. However, when you start allowing 20% of something in a society to do something that's not a good idea, that is the tipping point. So when you are quoting to me that only 40% of kids think marijuana is dangerous, it tells me that Informed Families has a lot of work to do to move that back up to 80. Because, see, that's that tipping point. Once 80%, it starts, think about that. What if all of us were all using pot? My husband was an airline captain. Well, come on. We've got to be realistic about what all this will mean to all kinds of things. So it's not a good idea. Are we strong enough to say to kids and to adults, it's not a good idea? Amendment 2 is a bad idea. So I'll stop on that, let you go back.
Thank you so much, Peggy. The next question is for Karen. Karen, you've worked on the prescription drug issue in Florida. How does your experience with that effort inform your views on Amendment 2?
Well, I tell you, in the past year, I've learned more about marijuana than I ever thought possible. As I was saying, is that it took the state of Florida over 7.5 years to get a database in place, and that whole time frame, our death rate rose from 7 to 10 a day till our lawmakers had to do something. We do not want to
We reached out to him, but I know he's a busy man. And he has
power that Big Pharma has had over Florida. We are allowing THC to become a commodity that's going straight into foods, and we have no idea the effect it has on the adolescent brain. We need those answers first before we start putting it in our Constitution. Thank you.
Yeah. Okay.
Thank you so much. I think somebody, for some reason, we're having a little bit of extra noise. Somebody just asked, can't we legislatively legalize medical marijuana without a constitutional amendment?
I'll take that one, Amy. Absolutely, we can. And if we're going to do it, that's the way it should be done. The legislature has already legalized what is called Charlotte's Web, a specific low THC strain of marijuana. That law went into effect this year during this past session, and the Department of Health is working on rules to get that up and running right now. So the legislature has demonstrated that they are willing to do what it takes to provide a safe form of medicine. Now, the legislature, of course, does have an obligation and a duty, and I think a good one, an important one, to protect the health, safety, and welfare of the state of Florida. So that is the best place to do it. And you can talk to your legislators. You can encourage them to look at this issue, to make a decision based on, evidence-based medicine rather than just anecdotes and emotion. And that is where it should be done, if at all. If it's in the statutes instead of in the Constitution, then we can change it whenever we need to. There's a legislative session every year, and they can call a legislative session whenever they need to. So that's where you have the flexibility to be responsive to problems. And again, I know that the Yes on 2 people say, well, the legislature wouldn't do it, so we had to do this. No, you didn't. You could have worked harder to get the legislature to do it. You could have waited longer. And if you wanted to do a constitutional amendment that just said the legislature shall enact laws and then leave all the details up to the legislature, you could have done that. But they didn't. So putting it in the Constitution is the worst possible idea. If it's going to go into Florida law, it should be done by the legislature, and it can be.
Well, thank you. That was actually our last question. So unless anybody has any final comments, we are going to end the webinar. I wanted to thank each and every one of you for participating. I want to thank everybody who is attending the webinar for joining us. We'll be sending you a survey shortly, and once you complete that survey, we'll send you a link to the certificate of attendance. We really appreciate your participation, and we're so glad to have you today. I want to thank again the Florida Sheriff's Association for your partnership, the Orange County Sheriff's Office, Susan, Karen, thank you so much, to Peggy for calling in from Kentucky, and thank you all, and have a wonderful afternoon.